I'm reading the Equal Credit Opportunity Act out of the New Reference Guide to Regulatory Compliance on PDF page 102. This is also known as Reg B. The Equal Credit Opportunity Act was enacted in 1974 to prevent discrimination in credit transactions. In 1975, the Act was amended and now includes the following prohibited bases: race, sex, marital status, color, religion, national origin, age, receipt of public assistance income, exercise of rights under the Consumer Credit Protection Act. At the time of the law's passage, the Federal Reserve Board implemented ECOA through Reg B. This regulation prohibits discrimination in any phase of a credit transaction based on the 9 bases listed above. It was revised in 1985 and an official staff commentary was published. To promote fairness and impartiality in lending, ECOA places certain restrictions on the information a creditor may obtain when evaluating and extending credit. It also requires that certain notices be sent to credit applicants who are denied credit or whose applications receive adverse action. In 1988, Congress amended ECOA through the Women's Business Ownership Act. This amendment increased notice and record-keeping requirements for creditors in certain commercial loan transactions. In 1993, the Federal Reserve again amended Reg B to implement the FDIC Improvement Act of 1991. These amendments provide applicants with the right to a copy of an appraisal report used in connection with an application for a loan secured by a dwelling. In 1997 and in 2003, the board modified Reg B to provide that results from self-testing are privileged and to allow creditors to collect race and sex information on non-mortgage loans for self-testing purposes. In 2011, with the authority for Reg B was transferred to the Consumer Financial Protection Bureau. In 2013, the Bureau issued rules requiring that appraisals and other valuations be provided to applicants for credit that will be secured by a first lien on a dwelling. This rule was effective on January 18th of 2014. I'm just going to write down self-testing. For ECOA. The coverage of the Equal Credit Opportunity Act is all types of credit, including consumer credit, credit extended to an individual for personal, family, or household purposes, and business credit, credit extended for business, commercial, and agricultural purposes. B, all parties participating in a credit decision. C, all methods of evaluating credit, including judgmental systems and credit scoring systems. Judgmental systems for evaluating credit and credit scoring systems for evaluating credit are covered. All aspects of the credit transaction are covered. Limited exemptions, public utilities credit, securities credit, incidental credit, and government credit. Covered prohibited bases, as I stated before. I may just skip the details within that section just for now. The requirements, starting with subpart A, general rules. Discrimination on any prohibited basis is prohibited during any phase of the credit transaction. Credit transaction is defined as every aspect of an applicant's dealing with a creditor, beginning with information gathering and continuing through to the servicing and collection of the loan. Effects test. An action does not have to be intentionally discriminatory. In fact, it may be neutral on its face. Discrimination occurs when a creditor's actions result in a disproportionate, unfavorable impact on a protected class unless a legitimate business need exists that cannot reasonably be achieved as well by means that are less disparate in their impact. Three-step process, A, B, and C. A, the consumer proves disproportionate adverse effect. B, creditor proves manifest relationship between the practice and creditworthiness. And C, consumer must show alternative policy or practice that achieves same result without disproportionate adverse effect. Number 2, discouraging applicants. The creditor may not make any oral or written statement in advertising or otherwise to applicants that would discourage on a prohibited basis a reasonable person from making or pursuing an application. B, creditor may affirmatively solicit credit from traditionally disadvantaged groups. C, definition of application. An oral or written request for credit made in accordance with the creditor's procedures for the type of credit requested. Information entered into and retained by a computer system qualifies as a written application. Roman numeral 1, a creditor may have a policy that only written applications will be accepted, but actual practice will govern regardless of written procedures. 2, an inquiry becomes an application when the creditor evaluates information and decides to grant or decline the credit. And 3, requests for written pre-approvals to be issued by the lender are considered applications. D, definitions of completed application. An application for which the bank has received all the information it clearly considers an evaluation, including credit reports, verifications, and so forth. Roman numeral 2, the creditor must be reasonably diligent in collecting information to complete the application, for example, ordering credit bureau reports. 3, written applications. Written applications are required for loans to purchase or refinance a principal dwelling and secured by the dwelling. Information entered directly into and retained by a computerized system qualifies as a written application. Disclosures must be clear and conspicuous, must be in a form the applicant can keep, except for monitoring information disclosures and disclosures that alimony and child support income need not be reported. Electronic delivery of disclosures, Roman numeral 1. The disclosures required by this section may be provided to the applicant in accordance with e-sign, including the requirement of consumer consent. Electronic delivery of disclosures. The consumer consent requirement of the e-sign Act is not required when the following disclosures accompany an application accessed by the applicant in electronic form. A. Application disclosures including the information requested for self-testing, courtesy title requests, marital status of the applicant, and income and alimony disclosures. B. Government monitoring information disclosures. And C. Appraisal notifications. 5. Language of disclosures. Disclosures may be made in any language provided English disclosures are available upon request. General rules under requests for information. A creditor may request any information in connection with a credit transaction other than the information specifically prohibited by Reg B. B. The creditor must request monitoring information on certain dwelling secured loan applications as required by Reg B or under any agreement with a regulatory agency or pursuant to a court order. C. A creditor may request information to determine the applicant's eligibility for a special purpose credit program. Race, color, religion, national origin, sex. A creditor may not request information about the applicant's race, color, religion, national origin, or sex except as specifically permitted by Reg B or another statute such as HMDA. A. Monitoring information. Creditor must request monitoring information when an applicant submits an application to purchase a primary dwelling. Requesting information. Information must be requested for an application primarily for credit for the purchase or refinance of a principal dwelling, including mobile home that is secured by such dwelling. Information to be requested includes ethnicity and race, sex, marital status, and age. Roman numeral 2, notice to consumer. A. The bank must inform the applicant that information is being requested by the federal government for monitoring purposes, and B. must inform the applicant that if the applicant chooses not to provide the information, the creditor is required to note race, ethnicity, and sex based on the visual observations or surname. The consumer refusal, A, B, and C. Applicant must be asked for information but may not be required to provide it. B. If applicant chooses not to supply information, the fact must be noted on the form. And C. The creditor must note race and sex based on visual observation or surname. That's only possible if the application was taken in person. Roman numeral 4, substitute monitoring program. A monitoring program established by an agency charged with administrative enforcement of ECOA may substitute for Reg B monitoring program. B. Monitoring information collected for self-testing. Creditor may request information on non-mortgage applications for the purpose of self-testing if the test meets the requirements of Reg B's self-test as described further in this chapter. Information to be collected includes race, color, religion, national origin, and sex. Creditor must give the applicant a notice orally or in writing that the information being requested for the purposes of testing the creditor's compliance with ECOA. Race, color, religion, national origin, and sex. I also have to note that I never realized that this should only be requested for credit securing principal dwelling. Request for credit securing principal dwelling. Principal residence. Now, the creditor must give the notice I previously discussed that the information is for the purpose of the creditor's compliance with ECOA. It's not required to be provided, and federal law prohibits the creditor from discriminating based on the information or on the consumer's decision not to provide it. If applicable, certain information will be collected by visual observation or served name if the applicant chooses not to provide it. Is another piece of information required in the consumer notice. The sex of the applicant may use courtesy titles only if the form discloses that the use of such titles is optional. So the institution has the right to request courtesy titles. The spouse or former spouse the financial institution may request information on the spouse if the spouse will be permitted to use the account or will be contractually liable on the account. The applicant is relying on the spouse's income in the request for credit, or is relying on alimony, child support, or separate maintenance payments from a spouse or former spouse. The applicant resides in a community property state, or the property securing the credit is in a community property state. The creditor may request that an applicant list all other accounts on which the applicant is contractually liable, including the name and address of the person in whose name the account is held. The creditor may ask an applicant to list all names under which the applicant previously received credit. Marital status. Creditor may not inquire about marital status in an application for individual unsecured credit unless the applicant resides in a community property state or is relying on property located in a community property state as a basis for the repayment of the credit requested. If application is for other than individual unsecured credit, creditor may ask for marital status using only the terms married, unmarried, or separated. Creditor may not inquire about income derived from alimony, child support, or separate maintenance unless creditor discloses that such income need not be revealed if the applicant does not want it to be considered in determining creditworthiness. Child-bearing capacities may not be inquired upon such as the birth control practices, intentions concerning bearing or rearing of children, or capability to bear children, and may inquire about the number and ages of applicants' dependents provided such information is requested without regard to sex, marital status, or any prohibited basis. Immigration status. A creditor may inquire about immigration status and permanent residence. Literacy, processing, and evaluating applications. The general rules. The institution may not take into account any prohibited basis when determining creditworthiness, and may consider any information obtained in evaluating an application, provided the information is not used to discriminate based on a prohibited basis. Marital status. In processing and evaluating applications, the institution may not use marital status as a basis for denying or granting credit, but may consider it for purposes in determining creditors' rights and remedies, and yet may not evaluate applications of married and unmarried applicants by different standards. When evaluating a joint application, a creditor may not treat applicants differently based on the existence, absence, or likelihood of a marriage between the parties. Age. The institution may consider whether old enough to legally enter into a contract, and may favorably consider applicants who are elderly, for example, age 62 or older. In a judgmental credit evaluation system, a creditor may consider age as it relates to another pertinent element of creditworthiness, such as the applicant's length of time until retirement, to determine whether the applicant will have sufficient income for repayment, and may use as a predictor in credit scoring systems if the system is empirically derived and demonstratively and statistically sound with certain limitations. For protected income, public assistance income. Institution may not consider whether an applicant's income is from a public assistance source, and may consider as it relates to another pertinent element of creditworthiness. B. May consider length of time public assistance income will be received, whether the applicant will continue to qualify for that income, and whether the income can be garnished. And C. Cannot discount or refuse to consider the following: part-time income, annuities, pensions, retirement benefits, alimony, child support, and separate maintenance payments to the extent they are likely to be consistently made. And 5. Childbearing and child rearing. The institution may not use assumptions or aggregate statistics relating to the likelihood that a group of persons will bear or rear children, or will, for that reason, receive diminished or interrupted income in the future. 6. Telephone and applicant's name. The institution may not consider whether there is a telephone listing in the applicant's name, and may consider whether there is a telephone at the applicant's residence. 7. Credit history. If credit history is considered, an institution must consider credit history of accounts that applicant and applicant's spouse are contractually liable for or permitted to use. On applicant's request, the bank must consider any information presented that indicates credit history is not accurate or is incomplete. And on applicant's request, the bank must consider a credit report in name of applicant's spouse or formal spouse that reflects applicant's creditworthiness. And 8. Immigration status. The bank may consider whether an applicant is a permanent resident of the United States, determine the immigration status, and any other information necessary to determine the creditor's rights and remedies regarding repayment. 9. State property laws. The creditor may consider state property laws in the process of evaluating an application. 10. Jointly owned property. The creditor must consider the value of the applicant's interest in jointly owned property. 11. Credit scoring systems. Evaluate an applicant's creditworthiness mechanically based on key attributes of the applicant and aspects of the transaction, and determine alone or in conjunction with an evaluation of additional information about the applicant whether the applicant is deemed creditworthy. And B. Credit scoring systems must be empirically derived and demonstratively and statistically sound with the following characteristics: 1 through 4. 1. Based on data that are delivered from an empirical comparison of sample groups of the population of creditworthy and non-creditworthy applicants who applied for credit within a reasonable preceding period of time. 2, developed for the purpose of evaluating the creditworthiness of applicants with respect to the legitimate business interests of the creditor using the system. 3, developed and validated using acceptable statistical principles and methodology. And 4, periodically revalidated using appropriate statistical principles and methodology and adjusted as necessary to maintain predictive ability. And C, are evaluated by regulatory agencies to determine whether they are empirically derived and statistically sound, and to examine the bank's policies on the use of credit scoring systems, training of bank employees on the use of the system, and the number of high side and low side overrides of the system. Extensions of credit is subpart D. A bank cannot refuse to grant individual credit on the basis of marital status, sex, or any other prohibited basis. Signature requirements, general rule, qualified applicants, unqualified applicants, and under qualified applicants, the creditor may not require signature of a spouse or any other person if applicant qualifies for credit alone. For unqualified applicants, the creditor may require a cosigner or guarantor, but may not require that it be the spouse. And third, a person's intent to be a joint applicant must be shown at the time of application and must be distinct from the means used to affirm the accuracy of information. Submission of a joint financial statement alone is not evidence of intent to apply jointly. B. Exceptions. On unsecured loans, and if applicant is married and resides in community property state, or property on which applicant relies is in a community property state, creditor may not require a spouse to sign any document unless it is necessary to make community property available in event of default if the state law denies applicant the power to manage or control enough community property to qualify, and B, the applicant does not have enough separate property to qualify. 2. If the applicant requests secured credit, the creditor may require a spouse's signature on any document necessary to make collateral available in the event of default. And 3. If the applicant relies on property owned with another person, the creditor may require signature of the other person only on instruments necessary to allow the creditor to reach property. 4. The creditor may require signature of any person on any instruments necessary to make secured property available to creditor on default. 5. According to FDIC guidance on spousal signature provisions, if the creditor requires a spouse's signature on an instrument that imposes personal liability, the creditor's belief should be supported by a thorough review of pertinent statutes, decisional law, or an opinion of the state attorneys general. Oh my God. C. For business purpose loans are subject to the same spousal signature rules regarding requiring the signature of the spouses of officers, directors, and shareholders. D. Integrated notes and security agreements. When a creditor uses an integrated instrument that combines the promissory note and security agreement, the spouse may be asked to sign if it is clear that the signature is made to grant the security interest and does not impose personal liability. E. Creditors may only consider the actual form of the property at the time of the consummation of the loan. The possibility of changes in the form of ownership, for example, changes that may occur with a divorce, may not be considered. FDIC guidance lists 3 requirements to ensure compliance with spousal signature rules. This is the review and revise policies, eliminate A through D, eliminate policies or procedures that are inconsistent with the requirements, expand loan policies and procedures to provide loan staff a specific guidance on state laws regarding requiring signatures, cover the laws of all states where the creditor institution does business, and create checklists to address situations when spousal signatures can be required. 2. Under the FDIC guidance list is to provide training to consumer and commercial loan staff and implement monitoring and auditing systems to check for spousal signature violations. 3. Designation of name. 4. Existing open-end accounts. 5. May not use a prohibited basis such as a change in name or marital status to trigger a request for updated information. 6. Credit-related insurance. 7. Creditor may require the personal guarantee of partners, directors, officers of a business, and shareholders of a closely held corporation. This requirement may not be made on a prohibited basis. For example, cannot require only married officers to sign a guarantee. And 8. Creditor may not impose requirement on any additional party that the creditor may not impose on the applicant And that'll be everything before I get to E, the special purpose credit section. But I suppose I have to finish reading designation of name. 3, the institution must allow an applicant to designate a birth given first name and a birth given surname, spouse's surname, or combination. For the existing open-end accounts, A, unless the applicant is unwilling or unable to repay, a creditor may not do any of the following based on the applicant's age, retirement, or a change in the applicant's name or marital status. Roman numeral 1, 2, or 3 require reapplication except as noted below. Change the terms of the account or terminate an open-end account. B, under existing open-end accounts, the bank may require reapplication if applicant is changing marital status and the account was based in whole or in part on the income of the spouse and the applicant does not appear to have enough income to support the account. And C, if reapplication is required, must allow full use of the account while the application is pending. And 5, I think I read 5, 6, credit-related insurance. The bank may not refuse credit to anyone nor terminate credit because of the unavailability of credit-related insurance based on the applicant's age. I read 7, I read 8. I'm going to break before special purpose credit.